All right, it's time for the YSL trial update. The Young Thug YSL trial crowd. I know I've got a lot of followers here on YouTube, and we just talked about the Tory Lanez appeal. If you guys are looking for any coverage or talking about that, you can go check out the replay. But we are going to do a preview of the big hearing that starts early tomorrow morning in Atlanta in the Young Thug YSL trial, where the new judge, Judge Whitaker, is going to be deciding a lot of different motions, including whether this trial is going to continue in the wake of the recusal of the other judge. So I was going to get Doug Weinstein in here to talk about some of the new filings and what we might see tomorrow. So shout out to the playback crew. Hit the like button if you can to let everybody know that we're here. And we'll see which filings we can get into first. Doug, thanks for joining us as always. I know you had talked over the weekend about a response that you'd been notified about to your mistrial request, but from what I've seen, there's only been one formal response filed to the mistrial request from the DAs, and it's to Bruce Harvey's mistrial request. Is that right? Have you seen any other formal filings?
I haven't seen any other formal filings responding to our request for a mistrial, meaning Mr. Kendrick's request for a mistrial. We were served, I want to say close to midnight or around midnight on Friday night, with a response to our motion for mistrial that was really just a cursory, 300-word statement arguing against it. But I didn't see that actually filed with the court, so I'm a little confused about that.
Huh. Yeah, you'd think they would want to respond to all those mistrial requests that were filed, because there were so many different arguments raised in each of them. Bruce Harvey's one that they did respond to is all about just the logistics of continuing with a new judge. Is that right? He's not arguing for with prejudice dismissal here. He's arguing for just a without prejudice mistrial, which is why some people didn't want to join in. But that it seemed like a pretty compelling argument. But is that one that you had joined in on? I know Max Shard declined because he wants to make sure it's with prejudice if they get a mistrial. But are you joined in on Bruce Harvey's motion?
Well, because of what Judge Glanville referred to as the Harvey rule and what Judge Whitaker has adopted, so we have the Harvey rule still in effect. All motions filed by any party or objections made by any of the defendants are adopted by all of us unless we explicitly opt out. So I have not opted out of Mr. Harvey's motion for Mr. Nichols, and I don't intend to. I think that Bruce and Nicole and Mr. Gardner, they make excellent points in their motion. And while I do believe that the mistrial should be based on goading, if the mistrial is based just on what Mr. Harvey puts forward, I will take that as well. Because again, I think that the reason that we're in this situation where it becomes impossible for a judge to parachute in is because of the actions of the prosecutor, and in a sense, that's goading as well. So I'll extend my goading argument to Mr. Harvey's motion. Okay.
Well, let's see if we can bring up, here's the actual response to the motion here. This is via the Thugger Daily account. And I found the case law or the examples that they were able to cite about the gap, the month-long recess, basically saying that it's not unprecedented and there's been other gaps like this too. That's compelling, but that's not really the heart of the motion, is it? I mean, it seems like there's way more problems beyond just the gap. It has to do with a judge taking over mid-trial like this, right?
I don't want to be in a position to argue Mr. Harvey's motion here, but I think his argument is far greater than just the recess. And I don't know if you saw it, but I believe that he has filed a reply to the state's response, or at least the one has been served. I was just looking at it earlier today, where I think that they do an excellent job of rebutting the state's responses.
Yeah, and it looks like that's here where yeah, well, we can. I mean, this isn't your filing, so we, like you said, you're not in a position to argue that. But the response that you saw to your mistrial, can you talk a little bit about what their argument was with that, or would you rather just wait to see if it actually gets filed?
Well, no, I can tell you what they said because I spoke of it earlier, so I have no problem doing that. They didn't really have any real argument, honestly. Their main argument seems to be a conclusory statement that mistrial is not appropriate. It's the usual. The prosecution did nothing wrong. The judge did nothing wrong. In the ex parte meeting, they cite, I believe, the King case. It's the only case they cite in the response. Just to state, look, the judge did nothing wrong, and we did nothing wrong. And that's pretty much all there is to it. It literally is about 4 or 5 very short paragraphs with really less than a page of text if you exclude the header and the title and the signature line. It only stretches a little over 2 pages. So they didn't have much response in writing. I will say that I have noticed that oftentimes in criminal practice in the state and superior courts in Georgia, that oftentimes both the prosecution and the defense will have often very minimal briefs, very minimal motions, and then they will expound at the time of oral argument. So perhaps that is what the state's plan is here. So I kind of, since they have effectively at this point not really responded to my motion, as far as I can tell, in any substantive way, I kind of look forward to hearing what they argue. Of course, I'll be at a disadvantage because I don't know what they're going to bring up because I haven't seen it.
Yeah. That I think we're all kind of on the edge of our legal seats tomorrow in terms of, I had to respond to Joseph, the Atlanta Journal-Constitution, wrote the article previewing tomorrow. And I said, I think this is a lot more legally intriguing than a Honda or a Nissan crashing into the side of a laundromat. And we finally got some really legal intrigue to this. But one thing I was wondering about, this is up on the screen is the DA's response to the motion to disqualify Adrienne Love and Simone Hilton. And just by the nature of what they're responding to, we wouldn't expect Simone Hilton and Adrienne Love to be the ones responding to this because it's a conflict. It seems like usually we see, it's his name Dane usually responds to this, but I noticed that Fani Willis is the one who signed this. And granted, her name is on everything because she's the DA, but what are the chances that she's the one who actually argues this in court on Monday, just given the stakes of this and the fact that, she's the one who signed the opposition?
Yeah, if I can generalize so far about this case, in the motion practice that's taken place in the course of this trial, most of the time her name is not on the pleadings. DA Willis's name is not on the pleadings. So her name is on this pleading. And Mr. Ohelski, who often is the one to draft a lot of these responses and motions, it's my understanding he's no longer with the DA's office. So it would be someone else doing it. And here I did see that DA Willis is the one that signed it. So I don't know, perhaps she'll be the one in court actually arguing this. I don't have any insight into this, but it would certainly not surprise me to see her there arguing it.
Yeah, here, let me pull up show the actual.
Yeah, you can go to the signature line here.
Signature here. Fani Willis, district attorney. And yeah, usually and my experience with court documents is when you actually see the signature while they might have had a clerk actually type it up, they're the one taking personal responsibility for it. So, maybe there's somebody else that she would subordinate this to in the office, but I don't know. It seems like there is a chance we're going to see her. We can't guarantee either way, but
the office has a lot of excellent prosecutors that they could bring in. In addition, they have outside counsel that they'll bring in under contract to do argument. So and to brief, but I didn't see any of those names on this particular filing. So I guess everyone will have to kind of be like us and just watch and see who ends up arguing this.
What stood out to me was she says this court should not abuse its discretion by disqualifying the prosecutors, especially where the June 10th, 2024 hearing about which defendants incessantly complains was proper, and where there are available to defendant other sources of the information about which he claims to need to examine Love and Hilton about at trial. One thing I've been wondering is, how is Whitaker going to approach the June 10th meeting? Is she going to weigh in on that, or is she just going to try to keep her hands out of it and say Judge Krause already decided that? But it seems like these filings are really setting it up where she's going to have to make her own opinion about that ex parte. And also, when you go back and read Judge Krause's ruling, it seemed like she kind of tiptoed away from making any real conclusive statements about it, because she even says, it could have been done. It could have been done in open court and perhaps should have. I mean, you see the perhaps, and it's like, what's this perhaps stuff? Aren't you the one who's supposed to be deciding this stuff? So do you think we're going to see more debate about that June 10th meeting, and this is going to force Whitaker to make her own decision on it?
I don't believe the propriety of the June 10th ex parte secret meeting is a closed deal. I don't believe the ruling on that is final at this point, especially the way that Judge Krause left it, as you said, in her order. So sorry, someone just sent me a funny text. Didn't mean to be distracted. I think that a lot of the motions filed by co-defendants counsel continue to raise the issue of the propriety of the June 10th meeting. I think my motion raises that to some degree. It's implicit in there. So I don't see how we don't go back to it. And I believe Brian Steele may actually, I'd have to look and see, I believe he has one motion specifically addressing that.
Yes, where he asked Judge Whitaker to basically rescind Judge Krause's finding that she generally agrees about the propriety of the ex parte. And then also the line about where Judge Krause wrote divorced from the hyperbole, referring to stuff in his motion as hyperbole. So yeah, I think that kind of will beg a decision. I was kind of thinking that Whitaker, from a strategic standpoint, with just that motion, it would be very easy for her to just say, look, there's no legal authority for me to revisit Judge Krause's decision. And that would avoid her making any kind of opinion herself about the June 10th meeting. But it seems like all the other filings have just kind of set it up where she's going to have to opine one way or the other about it. But,
yeah. I would think that she's going to have to get into that. So we will see. I think it's going to come up probably when I argue my motion for mistrial. I don't know when that will be, but I'm prepared to argue it whenever she makes that request.
Because that's one thing we've talked about, is just the question of what order is she going to take things in tomorrow? Because obviously the mistrial is the big request. If that happens, why consider anything else? But it seems like there are foundational arguments that could help the mistrial argument, like this ex parte thing. If she were to make a ruling that this ex parte was improper, then you could go to the disqualification of the prosecutors. And if she disqualifies the prosecutors, that kind of forces a mistrial. But it seems like that remains to be seen. Is there any kind of plan to make a request for her to view certain things first, or is, I mean, I know she would have that discretion, but are you planning to make a recommendation?
No, well, if she asks, I will. But if she doesn't ask, I'm not going to volunteer that. I imagine she's a very intelligent judge. I'm sure that she and her staff have looked at the array of motions before her. We weren't meeting today, so perhaps she's, in the chambers deciding on what order she's going to take care of things. So I leave it to her judgment to do that. One would think like the disqualification issue has to be raised pretty early. I think regardless of whether the ex parte meeting is proper or not, I certainly need to call ADA Love and ADA Hilton to the stand. I'm certainly going to be asking questions of Kenneth Copeland about them and what happened in that meeting. Fortunately, Brian Steele is taking the lead on that argument, and he's a brilliant lawyer vastly more experienced than I am, so I can rely on his skill to address those issues.
Is it possible that if there is some kind of evidentiary hearing, is Brian still going to try to call Woody? Well, maybe you can't talk about that, but are we going to see Woody testify in an evidentiary hearing?
It may be appropriate for me to call Woody.
Yeah. That's
Mr. Copeland. I really prefer to use his name, but yeah,
sure.
And that's not on you, that's on me. But I may be calling Mr. Copeland.
Okay.
We'll see.
Yeah. Well, I think, and then just in terms of logistics, I mean, we're in for a big scheduling change with just how early she's going to start. And I myself am bracing for the fact that she is going to start on time. I think everyone can count on that. We don't have any time to sleep in, but how are you folks preparing for kind of a more rigid schedule or a different schedule?
We embrace it. We've been there. We have been there when the judge has said to be there at 8:30 for a 9 o'clock start. So it really doesn't make any difference to us. As a matter of fact, I think it's great to start early.
Yeah.
And that, as I've said before, if we're going to continue this trial, let's do it. Our clients are locked up. I want Mr. Kendrick out of jail. If she wants to go to 8:45 until 7 or 8 at night, I'm fine with that. And I've had a judge, not in a criminal trial, but I've had a judge go from 8 in the morning till 10 o'clock at night before. It's very unpleasant on the litigants, but it certainly gets you through the trial.
Yeah. And especially with something like this, with she means business and there's no jury to worry about their comfort. There is the court reporter, but I noticed, I remember she said her court reporter is in the final throes of her career. I'm like, oh, I bet she can just power through. She's not going to be demanding a break. So
since I have tickets to Funny Girl tomorrow night, I fully expect court to go late.
Yeah, exactly. And this is a minor thing. And I know overall, like the defense isn't complaining about it, but it does seem like a change for the defendants that the no eating in court. I mean, they're going to have access to some food, but it seems like we've heard so much about how bad the food is in jail. I mean, how is that?
I don't remember. This eating in court thing that keeps getting played up. I don't remember a lot of eating in court. There are times where and this, by the way, the rules are constantly changing. It's the sheriff's department that sets the rules on a lot of these, on pretty much all of this. Judge Glanville has deferred to the sheriff's department. So sometimes they're permitted to have some food in court. So there's some months where they've been able to, there's other months where they've not been able to.
Okay.
As I recall, now, of course, I'm sitting in the front, so I can't always see what's happening behind me. But I don't recall people eating during the course of witness testimony.
It's more just like during the breaks, we see the cameras and I think
during the
it's
breaks.
more memorable because you're not used to really seeing that. But I don't think it just happens like
during the breaks. There may have been some eating in court.
Well, and really the person who was the biggest eater in court was Judge Glanville. It seemed like he was always snacking on something up there. So.
Really? I didn't even, I guess I don't notice that. I should, because I'm right up front, but I didn't particularly notice that.
Well, and the microphone, when you're watching the live stream at home, the camera picks it up. But, you reminded me of something, the difference between watching it on the live stream. The fact that Judge Glanville never starts on time, that doesn't change your schedule because he still gives you times to come to court. And it's not like you can just be like, me, just set your alarm and go check the live stream and just wait until it comes on and, oh, you're here. No, if he tells you a certain time, you got to be in court. So the fact that he never starts on time doesn't actually change things for you.
We were always there when he always is, but pretty much we were always there when he told us to be there and we were ready to go. As far as I know, the state was ready to, not necessarily hanging outside in the hallway, but when it was time to start, they would be, be there.
Yeah.
So anyway, I think it's great that we're going to start on time, and I am sure she will take the bench. Last time, I believe she started 2 minutes early.
Yeah. She did.
So now, after espousing being on time, I'll probably be stuck in Atlanta traffic and be 10 minutes late. But let's hope not.
Yeah. Well, I'm definitely kind of tried to readjust my schedule because that's a pretty early morning here, but it's exciting. I think there's a lot more legal intrigue and just kind of what are we going to do here moving forward. And you guys have filed a lot of great briefs. Have you seen any missed deadlines? Or I think the prosecutors filed some kind of motion technically past the motion deadline, did they? Or
they filed a motion on Friday, and as far my understanding was that, unless I misheard the judge, all motions by all parties had to be filed by last Tuesday, and then all responses by all parties had to be filed by Friday. And yeah, they filed a motion this past Friday. So I don't know where that's coming from.
Yeah. Yeah. Okay. Well, it'll be interesting to see just what the judge's approach to stuff like that is, because I think that's been an ongoing frustration. And while it might seem like a minor issue, the argument is that that's kind of a microcosm of bigger issues with deadlines and disclosures and that.
Yeah. This week is certainly going to be pivotal in this case.
Yeah.
I think this week really determines the course of what happens.
Yeah. Yeah.
I'm excited to get underway.
Well, in their motion Friday was to compel the release of evidence from the defense. Can you talk about the legal basis for that? Because I think especially to just lay people, they'd wonder, why does the defense have to disclose anything like that? I mean, is that your response to that too? But I remember Glanville siding with you guys, at least, saying that until it comes time to present the case, you guys don't have to disclose anything. But
yeah, that was the position that Glanville took. I mean, I believe the state's position was more like, if you opt into discovery, then you should be producing it now. That's not how I understand the case law to be. That's not how Judge Glanville was interpreting it. And I find it, what's the right word? Surprising that after the state failed to produce all of their discovery 10 days before trial, as required by Georgia law, and was producing discovery, terabytes of discovery 6 months into trial, that they would be fussing about our discovery obligations.
Yeah. There's definitely some hypocrisy there. And I know there's been, I think the Thugger Daily account pointed out the prosecutors kind of chiding the defense for asking Judge Whitaker to revisit a ruling by Judge Glanville, but then they've done the same thing in that motion to compel the defense, is basically reconsidering. But I think we've seen a lot of that here.
They did. I think they are continuing down the same course they've been on.
Yeah, and I saw somebody pointed out in a reply, and we've talked about this before, that, well, I think this person said that zealous advocacy is not supposed to exist on the prosecution side. I think I would disagree with that, and that prosecutors can be and should be zealous advocates for the state. But the point was the same, in that they're not supposed to just be throwing stuff at the wall and trying to get it to stick. In regards to legal arguments, that's more of a role for the defense, whereas the prosecution is supposed to stick with a narrative and have a coherent legal argument that they stick with. And I think that kind of provides the basis for a lot of the complaints about the prosecution in this case. Would you say?
I would say that's a lot of the complaints that the public has about the prosecution. Yeah. My biggest issue, I think, with the prosecution, well, I guess, is the lateness of the discovery. I think that's been problematic. And just, I just would like them to be more professional toward Brian Steele.
Yes.
In the courtroom.
And I think that, at least for me, as somebody who's going to be watching tomorrow, I'm really curious to see if there's going to be any guidance beyond just her be civil to each other, because we did hear that from Judge Glanville. He gave you guys some speeches about the need for to be civil to each other, but he never seemed to pick a side. And it seemed like tensions were getting to the point where somebody needs to say, like, who's right or wrong here? Like, who is more in the wrong? And there was never any kind of refereeing of that. It was just everyone was on the same table in terms of behavior.
Yeah, and that was frustrating. And of course, I've made errors. I interrupted DA Love at one point. I shouldn't have done it. And it was out of frustration, and it was wrong. And I hope I didn't do it since then. I hope to not do it again. And I'm really hoping that a judge who is not going to tolerate continued arguments, who's going to abide by time limits and such on argument. When usually in my experience, when a judge rules, it's over. You move on.
Yeah.
And of course, I'm mostly used to federal practice, but when a judge rules against me, it's time to move on. And I don't sit there and argue with them unless I want to be held in contempt. And that certainly has not been the case in this trial. And that's led to a lot of, and you ask what I'm frustrated with the prosecution, I guess that would be it. That's led to a lot of frustration on my part because you seemingly have won an argument and then the state continues to argue and continues to argue and continues to argue until eventually the judge changes his mind. I'd like to think, and whichever way the judge rules going forward, once the judge rules, the judge has ruled, and I'm happy to accept that and then move along.
And just that right there would speed up the trial tremendously, because I know one requirement she's put in is that the prosecution needs to have witnesses immediately ready, which will be great. But it seems like just the way Glanville read things, most of the problems weren't because the prosecutors didn't have a witness ready. It was just this kind of lackadaisical scheduling, like, oh, we'll see where the day leads us. And I mean, witnesses would be spread out over the course of like 2 weeks, almost like 7 days.
Yeah, I don't recall the prosecutor ever failing to, having a gap or failing to present a witness like one after the other in a timely fashion. I don't think we've ever really waited on a prosecution witness or cut trial early in the day because the prosecutor didn't have a witness there. So I imagine when Judge Whitaker said that, she was just kind of giving a general guideline for how to move the case along. I don't think it was a criticism of anything that's happened in the past.
And that's probably what she does in every case. I mean, that's what I thought when she mentioned the thing about the plea deal, because from what I understand, there have been no plea deals struck. Nobody is going to be surprising us by suddenly pleading guilty tomorrow, because she had said at the last status conference, be sure to talk about plea deals or something like that. But I got the impression that that is a standard line she says in every case. Do you think so?
Yeah, perhaps that is. I haven't been before her in trial before, so I don't really know if that's one of her standard lines, but perhaps it could be. We certainly are not going to be taking a plea deal tomorrow.
No. Well, what are some other things to watch tomorrow? What are the big issues? I mean, I think we hit it, but
yeah, I mean, I think the interesting issues will be who's going to be arguing which motions. I'm going to be really fascinated, maybe it's just because it's a legal geek thing, in what order the judge decides to take up the motions. Because in my head, I have an order that I think makes sense, and I'm curious if she follows it. She's obviously an experienced judge. As Judge Glanville might say to me, do you want to wear the robes, Mr. Weinstein? I don't want to wear the robes. So I will let Judge Whitaker make that decision unless she asks for input. But I'm curious to see how that goes. I'm wondering, given the quantity of motions that we have, if she puts any kind of time limit on us. I'm curious to see if she allows us to call witnesses. What, if any, limits she puts on that? Does she rule from the bench, or does she take it under advisement and rule later? So, I think, for example, and then bond motions, I think those should probably be after some of these other issues are argued, because I think they can be highly dependent on some of her orders. So there's so much that's up in the air right now that I'm as curious as I'm sure a lot of your readers and viewers are as to what happens over the next week.
Now, does she have a law clerk like Judge Glanville had? Was it Mr. Kearns? Or does she have access?
She does have a law clerk. Not a law clerk. She has a staff attorney.
Okay, staff.
Don't ask me the staff attorney's name, because I'm terrible with names and I'll embarrass myself by not remembering it off the top of my head.
Probably there's a chance for something like this. She is kind of huddling with some other with her staff attorney to look at this. It's not all.
Yeah, she has a litigation manager and a staff attorney, and we were introduced to them last Friday. And I've seen emails from them. So if pushed, I could look up their names. It'll take me a day or two of being in court with them. But I'm sure she's been huddled with them, plotting this out. This is a major undertaking that Judge Whitaker has. She's a highly experienced attorney. She's an experienced judge, former prosecutor. I fully expect her to go into this with a game plan,
Yeah.
but she has not. She has not indicated to us what a specific plan is, unless I missed it since I've been here the last half hour.
Yeah, definitely probably the highest profile legal issue of her career. And then just in terms of the legal intrigue that this has attracted nationally, it's gotta put some pressure on her that way.
Yeah. I mean, if you're interested in just watching legal issues, this is just going to be fascinating this week, I think.
Yeah, definitely.
I'm really looking forward to arguing the mistrial motion.
Yeah, no, that's gonna be great. So tomorrow morning, I'm planning on getting up early and streaming, but we'll keep updating.
For you, you're going to be getting up at the crack of dawn.
Excuse me, we haven't even talked about the gag order, but we covered that pretty well in the last live. It really seems like there's no legal basis for that. Of course, we've seen gag orders before, but as we talked about last time, the distinction is those gag orders are issued before a jury is seated and when the public is just consuming information. So it sounds like there's not much of a thought from the defense that these interviews are going to have to cease, right?
I don't know. I mean, I'm taking their motion seriously. That's why I spent so much time on the response. I don't know what the judge will rule, but I expect the judge to rule against the state here. But if the judge rules that, crafts some type of an order, I'll follow whatever the order the judge crafts, obviously.
Regarding the politics and Judge Whitaker's career aspirations, when I was following the Fani Willis hearing with Scott McAfee, people were talking about how he, as a former federal prosecutor, he has, of course, his sights set on an Article III appointment, a federal judge appointment, and that this is a really crucial hearing for that and just a big stage for him to kind of get a legacy going for that. Is there any kind of thought that Judge Whitaker has those same aspirations? She doesn't have the federal prosecutor background, but it seems like she could still line herself up for an appointment like that. Is there any kind of talk that she's interested in that?
I guess I'm just naive and optimistic and someone that buys into our judicial system. And I think Judge McAfee was making the rulings based on what he thought were correct rulings in that case. I don't think he probably viewed that as an audition for a federal judgeship.
I saw not in the discussion was not his actual rulings, but just the way he presented himself and organized the hearing. It really presents can you handle this? Regardless of how you apply the law, can you handle a big stage like this?
Well, I've been before Judge McAfee before, and I don't think he handled that any different than he handled anything else I've been before him. He's got a very what's the word? Like a calming demeanor, I think, from the bench. He doesn't get ruffled. He doesn't raise his voice. He's thoughtful, and I just saw him applying the same thing in that case. Of course, it's on a larger stage. But what's interesting is I sat in that courtroom during when we would get out of YSL early. I would sometimes go up there and watch. And it seems to me when you're in the courtroom, even though it's a big, important case, it has I know it sounds crazy, but it has a feel that it's just like any other case that's there. The courtroom's the same size. It's like in Hoosiers where they went in and measured the basketball court. And they're like, it's the same size court. And I don't know, it kind of felt like that in that case. So in our case, I'm sure Judge Whitaker is just going to treat it like anything else. I mean, look at the other thing about it. It was in Judge McAfee's courtroom. They didn't move it down to the larger, more, you could argue, ceremonial courtrooms that are down on the first floor like we're in YSL. So it was treated just like anything else that he would handle in his courtroom.
Right, because that's one thing to remember is that the courtroom one where this is in is not actually Judge Glanville's courtroom. He's stationed upstairs, but he'd moved his chambers down there for the trial, right?
That's right. So it was a little, I don't know what the right word is, disorienting on Friday when we go into the same courtroom, but now all the court personnel have been swapped out with others, as we got a new staff attorney, a new judge, a new litigation clerk, but we're in the same room. So that'll take a little bit to get used to.
Yeah. I see somebody ask, Viral Me Crazy, how positive are you that she will call a mistrial. How can you answer?
I'm not positive at all.
Yeah, I mean, it's questionable, right?
I think we should get a mistrial. That's why I filed the motion. But I am never going to guess on how a judge is going to rule on an issue.
Yes.
You know, we're lawyers. We're just so conservative, right?
Right. You gotta take it easy. But anything else we should talk about? Is there anything else?
No, I don't think so. But I appreciate you talking to me about this, and I hope everybody learns a lot as they watch the trial over the next few days.
Yeah, somebody says, when can we begin watching again? It's 8:45 a.m. tomorrow Eastern time, 5:45 a.m. and
sharp.
Sounds like she'll go through the week if she needs to. I mean, and you're definitely not expecting this to just be a one-day thing, right?
No. I think this is going to take all 4 days this week. We'll be there all 4 days.
Okay. Well, great. Well, hey, thanks so much for taking a few minutes to talk to us, and we'll check back.
Thanks, Meghann.
Thank you. See ya. All right. Right. Thanks, guys. Glad we're able to get some information in here. Give us a like. Let the algorithm know we're here. Thanks for watching live. If people have tuned in for the replay, what's up? But got a lot of news going on. If I did the Tory Lanez update on his appeal in another video, so I'm not gonna mix the two. But if you guys want to see that, go check it out. And yeah, I got to tell you guys, I am excited for tomorrow. Man, it's going to be early. I got to get up really early, but yeah, like I said, this is super interesting to see what she's going to do and how she's going to approach this, and et cetera, et cetera. So it's going to be worth getting up super early and doing the stream and getting some videos together for you all guys. I'll try to do the clips and everything, and I'll try to go live like during the break, like if there's a lunch break or something, and then maybe do something in the evening where I break it down for you all. But thank you guys for tuning in, and I will keep an eye out for some more filings. Although I think we pretty much got those covered. I think, like I said, I saw Thugger Daily in here. I've got to get him on a live sometime where I know he wants to stay anonymous, but he's talked before, so maybe he could just do an audio only thing where he goes over all the filings and talks about them, because he's been reading them all. But I think we covered the main stuff. Again, it's going to be really interesting to see who argues against the disqualification of the prosecutors, because Fani Willis signed that, and as Doug pointed out, she doesn't usually have her name on all the documents, and she certainly doesn't sign them. And usually they have that Scooby-Doo looking guy argue the law in motion, the Dane, but yeah, he's not even with the DA's office anymore, Weinstein says. So yeah, it'll be interesting to see if Fani Willis herself shows up tomorrow. I mean, I don't know either way, but I do think there's a chance she could be there. But we'll see. So thank you guys so much for tuning in, and yeah, check it out tomorrow, 5:45 a.m. I should have gotten the video things set up for today, but I'll do it right now so you guys can hit the notification and tune into my stream. But again, thank you guys, and I will see you guys later.